Hello dear friends, welcome back in our channel Indus Lex, and in this discourse we are going to learn the methodology to lodge an FIR or a complaint. Dear friends, if you are aggrieved from the act of any person and that is a type of offense, that is a type of a cognizable offense, you feel that you are a victim due to his act, and it is not the case of tort is another aspect of law where your remedy is some type of damages. But the criminal case is something different. Criminal case is threatening to the society at large. Suppose that there is a free fight is going between some people around the street, then it cause situation where general public face some trauma, whether it may be a physical or maybe it is a mental, that some time of type of danger, some type of apprehension of threat, they feel that the society is not safe. Therefore criminal law is something which penalized the person who commit this. So you have to be very careful while you are going to lodge a complaint or FIR in the police station or in the court, as the case may be. What is the first step you have to take regarding the registration of FIR? Dear friends, for the registration of FIR, you should write your complaint in written. You may give this information orally to the station house officer of the competent jurisdiction, but it would be better that you write your complaint on paper and then give it to station house office officer. After getting your complaint, the station house officer is duty bound to register your FIR. At this juncture, you should understand that whether the police officer can do any sort of preliminary inquiry, it is necessary to understand that Act already says that if the information of cognizable offense is given to the station house officer shall register the case in the to which we say first information report. And if police officer not do this, then what will be the remedy is that you may send the copy of that complaint to the superintendent of police, and maybe by the order of superintendent of police your case got registered and case crime number is allotted. But if even by sending the copy of the complaint to the superintendent of police your FIR is not registered, then you have a remedy, but not from the police but from the court. You may move application under section 173(4) of Bharatiya Nagarik Suraksha Sanhita, and then when you move your application under section 156(3), then the role of magistrate come into the picture. But it is necessary, before discussing the aspect of magistrate, what power he may exercise regarding your case, you have to understand that although the statute said FIR registration is mandatory when information of cognizable offense is disclosed to the station house officer, but in some cases police do preliminary inquiry. Whether the police has power to do preliminary inquiry in general sense, no. But when this question is dealt with by the Honorable Supreme Court in Lalita Kumari versus State of Uttar Pradesh, then Honorable Supreme Court said that police shall register an FIR on disclosing the cognizable offense, but he may do some sort of preliminary inquiry when matter is related to the matrimonial disputes, matrimonial relationship, when matter is related to the medical negligence, when matter is related to some sort of commercial disputes, or there may be some civil dispute related to the property or of purely civil nature. In these type of cases, police may do some preliminary inquiry before lodging the FIR. Further, in the cases of Prevention of Corruption Act, there is a provision for some preliminary inquiry on receiving the complaint by the station house officer. And if your complaint discloses the commission of cognizable offense, still no FIR is registered by the station house officer. Even you sent a copy of that complaint to the superintendent of police, still your FIR is not registered. Now you move to the court by placing an application under section 173(4). Now on receiving your application under section 173(4) BNSS, magistrate has three options, not power. He may accept your application and direct station house officer to register an FIR under relevant section. He may reject your application on the ground that your case is merely a malicious prosecution or it is of civil nature, it has given criminal nature only due to take advantage of criminal prosecution. And third option is magistrate may treat your application as a complaint case. At this point, you should understand the concept that when magistrate may refuse or magistrate can refuse or reject the application under section 156(3) apart from some extraordinary circumstances, when in the complaint itself there is disclosure of commission of cognizable offense. Because what happens, suppose that if 156(3) application or 173(4) BNSS application is not allowed by the magistrate, then the aggrieved person may approach to the session court or may honorable high court, and high court will remand the matter for again for deciding or registration of the FIR, or may direct the registration of the FIR on perusal the document. As we know, honorable high court can pass any order in the interest of justice by invoking inherent jurisdiction. So it is necessary to understand in which cases the magistrate may reject your application of 156(3). In the Priyanka Srivastava judgment, when there is a scenario created after the Lalita Kumari versus State of Uttar Pradesh, in which Honorable Supreme Court, the Constitutional Bench, held that the police is duty bound to register an FIR when he receive the information which discloses the commission of cognizable offense. And on this footing, when police refused to register an FIR, then aggrieved person approached to the magistrate by moving an application under section 173(4) Bharatiya Nagarik Suraksha Sanhita for the registration of FIR, and it was argued by the counsel that registration of FIR on disclosure of commission of cognizable offense is a mandatory, and if police is not perform its duty, it is a duty of magistrate to order him to perform their duty. Otherwise, what will be the benefit of the law? And therefore, a situation arises that whatever the police refuse to write an FIR, that will automatically ordered by the magistrate in the light of Lalita Kumari versus State of Uttar Pradesh to register an FIR. And in this perspective, in a year, Priyanka Srivastava judgments came in which Honorable Supreme Court held that 156(3) application can be rejected on the basis of malicious prosecution or no offense is there is no disclosure of offense, and it set out the guideline that every application must be supported by affidavit, and if the application is supported by the affidavit, magistrate may not or shall not, we can say, shall not reject your application for the registration of FIR. If magistrate don't think fit to order for registration of FIR, he may not order for the registration of FIR to the police, but he should convert that application into the complaint, or we can say that magistrate should register the complaint case on the basis of allegation mentioned in the application supported by the affidavit. Meaning thereby, magistrate should try to inquire about the case. When police not register the FIR, then people approach the court with very hope that they will get justice, and therefore court must took a more serious act and which should be visible to the common people, and therefore at this stage it is not advisable in the eye of Honorable Supreme Court that rejection of 156.3 or 173.4 application of the applicant when there is prima facie disclosure of the commission of cognizable offence. How this law is settled down? This law is settled in Raj Lakshmi versus Kailash Vijayvargiya, or we can say Raj Lakshmi versus Kailash Vijayvargiya versus state Kailash Vijayvargiya and state of West Bengal. It is a case. The fact of the case is that Raj Lakshmi is a BJP party worker where he shot it. He alleged some allegation about Kailash Vijayvargiya and two other party members. The legal proposition is that after such allegation, police refused to register the FIR, and on refusal of, or we can say due to non-registration of FIR, Raj Lakshmi approached the competent magistrate, and magistrate straightway reject the application of Raj Lakshmi under section 156.3. By such rejection by the magistrate, straightway rejection by the magistrate under section 156.3 application of Raj Lakshmi approached to the Honorable High Court, and High Court says that look, there is a prima facie allegation, and therefore magistrate did illegally when he reject the complaint of the Raj Lakshmi for the registration of FIR. So Honorable High Court remanded back the matter to the magistrate. And dear friends, again it is necessary to understand that whenever a revisional court or a court of higher degree is remanded back the matter to the original court, then opinion and reasoning recorded by the revisional court, or we can say appellate court, is not binding on the original court, and it is more advisable, legally warranted thing is that whenever matter is remanded back to the original court, afresh apply its judicial mind on the facts. And what Honorable High Court is remanded back the matter. What matter? The matter is that when police refused to register an FIR on the complaint of Raj Lakshmi approached to the magistrate by way of application under section 1. Magistrate also refused, we can say dismiss the application of 156.3 by Raj Lakshmi on the delay, on the ground of delay, that there is a huge delay of several years. And then Honorable High Court found that this order of magistrate is wrong, bad in the eye of law, and therefore remanded back the matter to the magistrate. When the matter is remanded back by the Honorable High Court and received by the original court, that is magistrate court, magistrate this time order for the registration of FIR against the Kailash Vijayvargiya. When FIR is lodged by the competent authority against the Kailash Vijayvargiya approached to the Honorable High Court for the quashing of first information report, that FIR. Meaning thereby, when on the basis of complaint Raj Lakshmi's complaint is not registered by the police, Raj Lakshmi approached to the High Court that look, police not registered my case, magistrate court not allow my application, what I have to do to get justice. And High Court remanded back the matter to the magistrate, and this time magistrate by the order of the magistrate, FIR was lodged against the Kailash Vijayvargiya. And when FIR is lodged against the Kailash Vijayvargiya approached the High Court for quashing of FIR, and High Court refused to quash the FIR. Now, by Kailash Vijayvargiya is agreed by the order of the Honorable High Court, where Honorable High Court denied for quashing of the FIR. Then matter reached to the Honorable Supreme Court, and Supreme Court held that magistrate cannot refuse the application under section 156(3) CRPC straightway. What Honorable Supreme Court says, when a magistrate at the first instance see the application and then decide to order to the police for the registration of FIR, then when the Honorable High Court remanded back the matter to the magistrate to decide afresh, what reasoning actually magistrate take, whether he applied his mind fresh to the complaint. Honorable Supreme Court held that no. Actually, what happened was, when matter is remanded back, because earlier the magistrate refused to register the FIR, and Honorable High Court remand the matter back to the magistrate to decide afresh. This time, magistrate, without applying his mind, order to the police for the registration of FIR, and Honorable High Court, Honorable Supreme Court is eager to find out on what basis, on what reasoning, what legal reasoning was there to take such drastic decision, why this opinion is changed in such manner that on the same set of facts, a magistrate one time order to the police that let register the case, or one time he not see any type of cognizable offense from the perusal of complaint. Here Honorable Supreme Court held that at this stage it is more advisable that magistrate convert the case and register the case into, convert the complaint and register the complaint into a complaint case. That application of 156(3) CRPC is converted and registered into the complaint case. And at this stage, when a case is registered by the court as a complaint, then at the stage of 203, when in the complaint case, complainant is examined, then other witnesses are examined by the court, and when after perusing the statement of complainant under section 200 and in 202 of the witnesses, courts conclude and decide whether to summon and proceed further, or drop out this matter by rejecting the complaint under section 203. And at this stage, if on the basis of Priyanka Srivastava judgment, your application is rejected at the stage of 203 CRPC, it is very tough to get further relief. But if court proceed under section 204, then you have to be aware that let us not your summoning order be quashed. Apart from Priyanka Srivastava judgment, your matter should be of criminal nature. There may be a civil dispute, but you have to be focused how you can say or how you can show your victimization, how you show that offense was really committed. That is up to you. But law is very clear that if the police refused your case, you have remedy before the court, and your 156(3) application may directly can't be rejected by the magistrate, has no power to reject the application of 156(3) in such manner. If magistrate want to reject your application, he should register the application as a complaint, proceed according to section 202, and then magistrate has to decide whether to dismiss this case or further proceed with section 204 and issue the summon against the accused. So dear friends, if you are aware about these laws, you may write your first application on some sort of e-governance portal such as Jan Sunwai, UP Jan Sunwai, by which to effectively contest your case, such as using RTI. I hope this video will helpful for you to register your case. Thank you.